Our next case, number 4, Klickitat Land Preservation Fund versus Klickitat County. If council would please come forward. Our next case again is Klickitat Land Preservation Fund versus Klickitat County. Mr. Telligan, tell me if I'm mispronouncing your name.
It's a soft G, Your Honor, Telligan.
Telligan.
Thank you so much. Yes, Brian Telligan on behalf.
Hold on a minute. Let me ask, who's arguing on behalf of Klickitat County and the other parties?
Good morning, I'm Joseph Rayberger here on behalf of Under Canvas Inc.
Hey, good morning. My name is Rebecca Cranston. I'm here on behalf of Klickitat County.
And who will be arguing, or maybe both of you will be?
We'll both be arguing. I'll be taking 12 minutes and Mr. Cranston will be taking 3 minutes.
And will you be going first, Mr. Rayberger?
Yes, John.
Okay, thank you. Mr. Telligan, we have, I know that you have a diagram here. We are recording this for later use on TVW. The camera will not be picking that up, just to let you know.
Yeah.
Also, if you wander away from the podium and to point out things on the diagram, the picture that you have, you're not going to be picked up as to sound.
Fair points. Yes. So I'm more concerned with what you see.
I can't see it very well. It would be better if it was by you.
That'd be perfect. I'll move it. Thank you.
Promise to sit away. Can you see it? Better.
Is that better, Your Honor?
No, actually farther away.
How about I put it right?
Well, and the lighting is, that's better.
And counsel for the county and Under Canvas, have you seen this before? Just have not.
This is all information taken directly from the record, and the images are from the record as well. You can see the AR numbers in the bottom right-hand corners of the images.
Can you see it, counsel, from where
No.
you're at? Do you want to?
How about I just turn it slightly? That way everybody. How's that? Too much of an angle or?
Move it forward. So
Maybe we could just take a minute to let.
Do we want to take a minute?
Response council, just take a look at it.
Sure.
Got it.
Okay.
okay, please proceed, Mr. Telligan.
Thank you so much. Brian Telligan on behalf of the appellants in this case, Klickitat Land Preservation Fund, and Dennis and Bonnie White. KLPF is a land preservation fund in this area. You can see the land that it manages is in yellow right there, a little shaky.
Mr. Telligan, I failed to ask how much time do you want for rebuttal?
5 minutes, please, Your Honor.
Please continue.
Thank you so much. So this case is about that road. If you can see it in the bottom right-hand corner. Right there. And that's the road right there. That's Oak Ridge Road. Now, does that look like the kind of road that you can drive a mile of cars down in one direction and 6 fire engines, 6 brush rigs, and a bulldozer in the opposite direction? Does it look like the kind of road that you can do that? And does it look like the kind of road that you can do that on without interfering with all the other area residents that live in this area, all trying to get out in the event of a wildfire? Now, those questions are very meaningful because Under Canvas is proposing to build a recreational resort the size and density of a large subdivision right there on the red parcel where the arrow is.
Mr. Tellison, the issue that I struggled with in this case is we are not fact finders. So
No.
even if we think, gosh, you know, I'd like a larger road, this is not too far away from where I live. You know, we don't, what is the legal error? Could you focus on the legal error instead of asking us to find as a matter of fact that we would like a wider road?
Right. You are not fact finders here, but you are here to review what it is that the county considered before it made its MDNS under SEPA. And you are here to ask whether the examiner properly found that Under Canvas met its burden to prove the criteria necessary for permits, which include proving that this location is safe to public health, safety, and welfare. And what my point to you today is simply that there's an obvious problem here. It's an obvious problem we raised at the hearing below. It's an obvious problem we raised at the Superior Court. It's a problem that the county had to consider under SEPA. It had to conduct a realistic, searching, methodical evaluation of potential impacts. It's an issue that Under Canvas needed to address in order to get a permit. And these are issues that the county did not address.
But they saw this, I mean, right? I mean, they saw this, they heard concerns about this. The witnesses who testified, and it was split testimony, you know, about this. This isn't something that as a matter of legal error, there was a refusal to consider something, right? The witnesses saw this and the court and the administrative agency saw this and the judge saw this and reviewed the case.
Well, certainly there was testimony at the hearing. Okay, that testimony postdates the MDNS. Now, when you're asking the question, is the MDNS supported by rational searching agency analysis? You need to look to what the agency actually did before it issued the MDNS.
Thinking how wide the road was, right?
There's no evidence they knew how wide the road was, Your Honor. We tried to raise that issue many times before the agency, before we got to the hearing, saying this road is not even 20 feet wide. Under Canvas's experts kept on saying the road is 20 feet wide. We went out and finally documented that 2,000 feet of it are less than 20 feet wide. At the hearing, the county engineer got up, the county engineer was deemed not to be an expert, okay, but still testified, we went out there and we think about 240.
That's a factual dispute. So are you saying that at the time the DNS was issued, that there wasn't an assessment and it didn't occur until the hearing? So how could you affirm something at the hearing level when it was never considered previous? What is the legal argument?
Yes.
Because what you just decided to is your classic, he said, she said.
Yeah. So what you just said, 100%, and it's in black and white. Because when I got the SEPA responsible official on the stand and I cross-examined her, this is also the head of the county planning department. Okay, this is the person in charge of making the decision, in charge of doing SEPA review. I asked her, I said, quote, did the county or anybody else evaluate the potential conflicts of evacuating guests, interfering with other residents trying to get out in the event of a fire? Her answer was, quote, no.
Well,
No elaboration.
Did you go out to the road and see how wide it was? I mean, you're saying that the issue of how they didn't know how wide the road was there testimony that?
There's two issues. So yes, we raised the idea of the road being less than 20 feet wide generally just being unsafe because they're going to increase the traffic from 34 to 65 trips per day to 300. That's just a general safety problem. But irrespective of the width of the road, the question is, how are you going to evacuate all the people? If you need to get a mile of cars out of this place in the event of a forest fire, how are you going to do that while getting firefighting assets in and getting everybody else out who lives in the area? We're saying that was something that the county needed to consider, and the SEPA responsible official said she didn't. We also asked her, I said, quote, did the county or anybody else evaluating or assess the possibility that evacuating guests could interfere with incoming fire trucks? And her answer was no. This is at CP 765. I said, did you, as part of your SEPA analysis, ask these questions, evaluate these issues? Her answer was no. She did not do it. Nobody else did it. There are only 4 people in this entire case, 4 people who actually really spoke. Well, actually, it's not true. There are 4 people plus the dozens of residents who all have testified that they're terrified of this project. They all familiar with the road say there are obvious problems with trying to get people out, but 4 in particular, my 3 experts. Ron Scott, who is a fire cause and insurance consultant who deals specifically in pre-cause fire assessments. He's a fire expert. He says this is a death trap. People are going to get trapped. This is a dangerous proposal in terms of fire. And my 2 traffic safety experts, Ross Tillman and Gary Norris, both say obvious problems, major problems. Those are the 3 experts in the case. The 4th is the Houston fire chief, who testified very vaguely, no problem. We'll do it. When I tried to cross-examine him, he was found not to be an expert, the local fire chief. So now you only get it one of 2 ways. Either he was an expert and I was entitled to cross-examine him, but under canvas said, no, he's not an expert. The county said, no, he's not an expert. He has no expertise. So that's the law of the case. The Houston fire chief, as a non-expert, testified no problem. If I had cross-examined him, if I would have been allowed that, because it seems bizarre that the local fire chief is not an expert in fire-related matters, I would have asked him this question. How do you get a mile of cars out of there? How do you do it? How do you get a mile of cars out of there?
But isn't the response, there's a couple of responses. A, there's a requirement to widen the road at all areas. B, there's a requirement to do some fire suppression methods. And I understand that the fire suppression doesn't address evacuation, but there is a requirement that there be an evacuation plan approved by the local officials prior to a final occupancy permit. And couldn't you appeal that? If you don't like that, you don't like the plan that happens, you said this is not a safe plan, couldn't you appeal that?
I don't know. I mean, the rule says they have to have a plan, you know, so that they do the best they can. They say if
you cannot occupy this unless we approve your evacuation plan.
well, it says they have to have a plan, you know, and so it's true, right? So it is true under SEPA. If you're dealing with things like, you know, how are you going to control stormwater or something like that, when it's just about, we know we got to control it. The only question is how big of a retention pond do we build, right? It's fine to say, well, down the road, we'll figure out how big the pond has to be. Okay. But right now, we don't even know if it's possible to engineer your way out of this problem. There's only one road in and one road out.
This problem, I mean, they can do all of this work and then they're going to come up with an evacuation plan. And if the evacuation plan doesn't work, it's all going to be for naught.
There are 2 problems with that, Your Honor. One problem is SEPA is supposed to be done up front so that you don't get a snowballing effect. You need to evaluate the impacts first so that you don't taint the future process by building administrative inertia. That's the whole point of SEPA, or that's one of the big points of SEPA. Problem number 2, in order to get the permit that they were given, a conditional use permit and a recreational park permit, in order to get those permits, they had to meet their burden. And their burden for a recreational park permit says that a recreational park, quote, shall not be permitted in any area that is unsuitable because of any feature that, quote, may be harmful to public health, safety, and general welfare. They had to address these issues in this proceeding to get these permits. And so the problem is, under SEPA, you have to look at these issues. The county said they didn't. I asked the SEPA responsible official dead on, did you evaluate these issues? The SEPA responsible official said no. So we can come up with hypotheses that maybe the road's going to be wide enough. Maybe they'll come up with an adequate plan.
They're required to make it wider.
Because the SEPA responsible official is the one who's supposed to consider that stuff, who's supposed to make the evaluation. Is 20 feet wide enough? And I'll tell you why there's skepticism. 20 feet is the standard for a fire access road to get to 3 or 4 parcels. It's a fire access road standard for small roads leading to 3 or 4 parcels, not the standard for a road leading to a 95-unit luxury camping resort and hundreds of other homes in the areas.
Is there a different standard that would apply that was not applied?
Yes, the code actually says that the county's transportation standards say 20 foot is the minimum, 12 feet is desirable. So even the county standards say 12 feet is actually better for a road like this than 10 feet per lane, not the total width. So at the end of the day, Your Honors, you know, My clients have been accused,
You're
if you,
intelligent, your rebuttal time, you can continue if you wish, but it will be charged against your rebuttal time.
thank you. I said it for 5 in case I might go over. I just want to say one more thing before I sit down. My clients are terrified. Okay, why else would anybody care about a camping resort going in? Why else would anybody care? But you know what they do? And if you look at the transcript, dozens and dozens of area residents, everybody who lives on this road, who knows that road, who's driven that road, who knows it intimately and firsthand, every single one says, there's major problems here. And I'll tell you, we have to see the responsible official. And she said, they didn't consider them. Thank you.
Mr. Rayberger? Mr. Rayberger, we will not be keeping track of your 12 minutes. We're only keeping track of the 15 minutes, so.
You're on your own.
on your-
Ms. Granson.
Yeah.
I appreciate the clock here.
There you go.
Good morning, Your Honors, and may it please the court. My name is Joe Rayberger, here on behalf of Under Canvas Inc. We're here to ask the court to affirm the hearing examiner and the Superior Court's higher affirmations of the SEPA threshold determination. Here a comprehensive mitigation determination of non-significance. And to affirm the hearing examiner's approval of a conditional use permit and recreational park permit for the proposed camping facility. Finally, as appellant's arguments have been rejected twice, and Under Canvas has prevailed at both the county level, again on appeal before the hearing examiner in a 2-day hearing, and then again in an all afternoon hearing before the Superior Court, we'd ask this court to award fees.
But oh, I'm sorry, go ahead. I was going to say we exist to reconsider those decisions, so.
Right, absolutely, but that's the basis for fees is prevailing twice below under RCW 484.
Let me ask you a question right away that was suggested by counsel's argument. Is the permitting process, does that, as he argues, accelerate your obligation to demonstrate safety in a way that doesn't permit? I mean, the SEPA official is permitted to postpone certain environmental conclusions, but does the permitting process accelerate the requirement to make those decisions?
I'm not sure if I understand the use of the term accelerate in this context, but I'll
Well,
say.
meaning you can't get the permit until you've demonstrated you've addressed these safety concerns.
Well, I will say that let me answer the question by saying that I believe the record does demonstrate that Under Canvas has met the safety concerns, including those re-articulated here by Mr. Telligent. These were the same issues that were argued before the hearing examiner. These issues were raised before the county at the time during the SEPA process, and there were a myriad of conditions imposed in the MDNS that directly address this very issue of fire safety, fire risk, and evacuation.
Well, maybe let me be more clear. My understanding is that SEPA official can say we're going to need an evacuation plan, but you can provide that later. It sounds to me like counsel is arguing that the permitting process requires that evacuation plan to be completed now.
Yeah, we've cited 2 cases in our briefing, both the Quinault Indian case and the West 14 case, which both discuss that SEPA does allow for and specifically contemplate future plans to be put in place. The Quinault Indian case, for example, was that an oil spill prevention plan to be put in place. So when the court in that case affirmed the decision saying, yes, that's sufficient. There should be a plan in place at the time of operation. Just like here, there should be an approved evacuation plan at time of occupancy, finding site plan. Actually, it's very reasonable, and there's testimony in the record from the responsible official about why that was done here, because an evacuation plan in this case is site specific. If you look at there is a template evacuation plan. It's attached to the wildfire mitigation plan that's in the record that was prepared by Under Canvas experts Galen Wright. In the text of that record report himself, he specifically addresses evacuation issues, discusses that the roads are capable of fire, both DNR and Fire District 3 trucks and equipment accessing the site, discusses the proximity of the local fire department, and attaches as a template to that, or as an exhibit, a template evacuation plan for another park operated by Under Canvas. Both the report and the template plan were routed to Fire District 3 and DNR. These are considered agencies with expertise under SEPA. Both of them found no concerns with either. And Fire District 3 specifically said they were confident an evacuation plan could be put together that would be sufficient. And those evacuation plans, if you look at them, they very much address the site specifics of the layout of the property.
Could
You know, where to
explain a little bit
congregate.
more why the site specifics couldn't be addressed early on? I've tried reading this as in generalities. I'm wondering why was that not possible at this time?
Because it goes into very much detail about, you know, for example, where are fire extinguishers on site? Where should folks congregate when a fire may break out? Where do they evacuate? Which exits? Well, the final site plan for the under canvas facility, which is a 95 tent structure facility, that hasn't been laid out yet. I mean, there's a template plan in place now, but as the responsible official testified, that doesn't come until the binding site plan phase. And so what we have in the record now is a wildfire mitigation plan, which discusses the general aspects of it. We've got a template evacuation plan, which Fire Districts 3 testified to as being, quote, comprehensive and would be adequate. And we just need to await that binding site plan. So we have a final site configuration in which to create the details of that plan.
Well,
But there have been no
quandary, though,
concerns raised about the plan itself.
the biggest quandary, it seems to me, that the challengers are raising is not how you get off the site, but how you're gonna deal with the fact that you've got a 20-foot wide road and you're gonna have a lot of people that need to get out and a lot of emergency vehicles that need to get in. And that seems like something that could be addressed now.
And I will tell you that was addressed. That was absolutely addressed. I'd invite the court to take a look at, I mean, the very comprehensive nature of the SEPA review process here. I'd start with the declaration of Pam Zander, who is an expert for under canvas, and walk through that. But compare, for example, the preliminary MDNS that was issued by the county. The under canvas submitted a very thorough environmental checklist, and the county issued a preliminary MDNS, invited comments from agencies, and routed all of under canvas's reports. They then received comments from the public, from Fire District 3, from DNR, from other agencies with expertise, the Department of Ecology. And then in order for under canvas to respond to those comments, the county withdrew that preliminary MDNS and several months later issued a new MDNS. Well, I'd compare those two because what you'll see in the MDNS that was issued is that the county addressed these very issues. For example, condition 16, implement all the recommendations of Public Works to confirm that all roads serving the project meet Washington Department of Transportation standards for fire truck access. That wasn't in the original, or that one might have been, but they weren't all. Condition 17, all road access for the facility meet county standard for, again, quote, fire access road. Roadway requires roadways be a minimum of 20 feet in width, restrictions on side slope and crushed rock. All of these conditions that you see in there with respect to these roadway conditions, I'd compare those to the comments the county received from Fire District 3 at AR 223 to 229, because they implement those very suggestions. So essentially what happened here was they received comments on things like fire access, emergency services, evacuation, went back, received comments from the local fire district, then incorporated those comments into mitigating conditions in the MDNS. And those address these very issues that we're talking about. I think they're pointing to one particular condition, that this evacuation plan, which is awaiting binding site plan approval, is necessary, but all of these conditions, they're all cited in our brief, including a vegetation management plan, which, you know, on its face sounds like a landscaping plan, but really it's a specific plan to trim trees and brush along the roadway, both to improve site distance and ensure access, and also to reduce fire loading. So I would answer that question by saying that these were addressed very comprehensively, and then these very same issues again were debated extensively before the hearing examiner. And I, you know, point the court again to the authorities cited in our briefing. City of University Place case, evidence should be viewed in the light most favorable to the party prevailed in the highest form that exercised fact-finding authority. The hearing examiner was in the best position to evaluate the evidence in this case. Consider these very issues that this court's being presented with today. And very pointedly, he said that the experts of under canvas and the county public works director were, quote, more convincing than the experts put on Mr. Norse and Mr. Tilligan put on by appellants.
I had a question for you. So looking at these photographs that appellants have put on, I mean, there's a requirement that the road be widened to a minimum of 20 feet. Would these roads in particular, for example, be widened or changed? Do you think?
If these roads are access roads along Oak Ridge Road, and if they are less than 20 feet in width, they will absolutely be widened because that's a condition in the permit.
So it'd be fair to say that some of the photos that they may bring us to look at may not be representative of what it would look like after there's compliance.
If they are less width than 20 feet, they will be widened, and the Public Works Director testified they would not approve the project unless.
And
that was
remind me of the
completed.
vegetation plan, is there, apart from the width of the road, is the vegetation plan to address vegetation on the side of the road?
On the sides and, yep, exactly, on the sides and within the 60-foot easement associated with the road, both to mitigate for potential fire risk and to improve sightline distances around curvatures.
So is there a clear zone off the side of the road? Or is there a zone off the side of the road that will be cleared of trees?
That's what the vegetation plan is intended to provide for.
Do you know what that zone is?
I do not. I would again also, I want to sort of reposture this case in the context of how it's been briefed and presented by appellants, which is asserting that there hasn't been even prima facie compliance with SEPA here. I think the record here is very much distinguishable from any other case that you'd see where that becomes an issue. The record here on this SEPA review is exceptionally robust. Under Canvas presented multiple experts. This went through an MDNS, a response to comments, the withdrawal of that MDNS, a new MDNS, 2 full days of hearing before the hearing examiner considering these very issues, all of which demonstrates that there really is no question that there's prima facie compliance with SEPA here. I mean, that's where you've got a case where there really was no consideration of any environmental factors. And the cases cited, for example, the Lucilla case cited by appellants, there was no SEPA review done at all. Here, the county was very diligent, not only in doing their own review, but requiring multiple rounds of traffic studies. Under Canvas completed no less than 3 traffic studies. At the county's request, Under Canvas also commissioned a third-party reviewer to come in and review those traffic studies. So all these issues that are raised in the briefing, there's no question they were thoroughly evaluated.
Go ahead.
I'm just wondering, with respect to the conditional use permit, was there ever specific finding that the property was suitable for the proposed use as required by the code?
I would say that I would refer you to the hearing examiner decision where, yes, I think he made specific findings to that effect. And further incorporated the entire SEPA appeal record into that conditional use permit document. We'd ask the court to affirm the decisions below. Thank you.
Ms. Cranston?
Good morning, Your Honors. May it please the court, Rebecca Cranston on behalf of Klickitat County. Well, I don't want to be repetitious of what Mr. Rayberger has said. I do want to step back and take the opportunity to explain that the county believes the MDNS was properly issued in the decision of the hearing examiner and the Superior Court should be upheld. There are 2 broad issues here today that overlap the roadway and fire danger. Concerning the roadway, there was extensive research done into the roadway as it stands now and what needs to be done prior to the issuance of the MDNS. There were 3 different reports done by DKS, hired by Under Canvas. An independent contractor was hired to review that and worked with Public Works. At the end of the day, there were 9 conditions in the MDNS to address the concerns about the roadway. Mr. Telligin would like to have the roadway wider than 20 feet, but that is what's required by Title 12, which is specifically a fire access road and designed to consider fire access in the event of a wildfire at this location or any location along the roadway. Concerning fire access, and again, this overlaps, Under Canvas and the county consulted with Department of Natural Resources and Fire District 3. Fire District 3 submitted a letter prior to the issuance of the MDNS that stated that they believe that fire could be addressed if a wildfire were to occur. Further,
Let me take this
Sure.
time to ask you about something that
Sure.
wouldn't overlap. In some cases, the challengers have identified discrete issues that they say were not addressed. And one of those is the fact that this is open range and that there are cattle ranchers that move their cattle on the road. Was that addressed? Their contention is that wasn't addressed at all.
And the county's position is that that was purely speculative. They did not show, their road studies show no cattle on the roadway at any point. There's never.
Well, it
been a
is open
history-
range, isn't it?
It is open range, as is much of the county for sure. But there's no history of accidents on the roadway with cattle. There were no cattle seen during those road studies. It was believed to be speculative. There's no statement about how often range.
Okay, so no history of any problems, but there are ranchers that do graze cattle in that area, aren't there?
There are, as in much of the county, it's graceland, yes.
But your response is that the risk is speculative.
Speculative, yes. So I realize we're about out of time, but I do want to take the opportunity just to say that the county believes the issuance of the MBNS was proper and it should be upheld. Any further questions?
Thank you, Ms. Cranston. Mr. Intelligent,
Thank you.
you have 3 minutes and 53 seconds.
I'm sorry, what was that?
You have 3 minutes and 53 seconds.
Perfect. To Judge Pennell's question, you asked, did the hearing examiner address the condition saying that under canvas must prove that the property is suitable for the proposed use? The answer is no. It's not in there. You can look at it.
There's not a finding.
There is not a finding on that issue. So Mr. Regberger said, yeah, the answer is no, he did not.
Is it the proper step for us to take in that connection though, to send it back and allow a finding to be made if that was the intention?
If you,
I mean, I don't think we should make the finding ourselves, which I think is what happened at Superior Court level, but.
right, yeah, but I think you should address all other issues too. I mean, that's fine to send it back for that, but you know, there are bigger questions. One thing about, you can still see me, he mentioned the vegetation management plan that they're going to clear to make sure that it's safe. Well, that plan applies from here to here, because that's their property. The road also has to cross land owned by the Woodwards. They have no authority to do it there, nor do they have authority to clear vegetation anywhere along there. So the vegetation management plan, you know, from there to there, hopefully if there's a fire, they make it out. If there's not a tree across it or, you know, stalled vehicle, they might not die there, but if they can get out, it will help them. They can't clear the vegetation anywhere else. Now, the county says, my clients would like a wider road. My clients don't want a wider road. They don't care how wide the road is. What my clients want is for somebody to ask the question, how do you get the people out and the firefighting assets in? Because in 2017, there was a fire right up here. I talk about it on page 10 of my brief, the Dry Creek fire. There was a fire. They had to close down the entire highway to have enough room to get the firefighting assets in. That's in my brief. If they had to close down the highway to get enough firefighting assets in, a 20-foot road that is still unpaved, is still steep, has sharp curves, you ain't gonna do it. And all we want is for someone to answer that question, and they don't have to have a plan right now. They can do a plan later, but they know what they're gonna build. There is a site plan in the record. SEPA says you evaluate the impacts of the proposal. We know what the proposal is. The county is required to take a searching, methodical view, assessment of environmental impacts. This is one of them, and there has not been any evaluation. And we know that because that is what the SEPA responsible official said when I asked her. And as far as the cattle, there's obviously evidence of cattle. We have a photograph in our brief, and the area residents say they're black, and that there are multiple times when they have been stopped suddenly on the road because of cattle. Yes, it's a problem. When I asked the SEPA responsible official, I said, do cattle pose a traffic safety hazard? Like my traffic safety expert said, she said, it's possible. She said it's possible, and she didn't look at it. So at the end of the day, no one cares if there's a resort here other than the fact that it puts lives at risk. It is an issue that the county needed to consider under SEPA and not push it off to the future. Nobody ever addressed that issue. There's lots of paper in this case, but under Canvas, despite talking about the process and talking generally, has never pointed to a single piece of paper where anybody actually evaluated these issues under SEPA, nor did under Canvas do it for its permit. And, you know, as far as the acceleration issue, yes, to get this permit, it is under Canvas's burden for a conditional use permit to prove A, that the property is suitable, and B, that public facilities, which would include the road, are adequate for the proposed use. And to get a recreational park,
Your time has expired.
they have to prove that it's safe. And they didn't, Your Honor.
Thank you.
Thank you.
We will be in recess. I noticed that there